Good afternoon, everyone. I'm Jim Duff, the Executive Director of the Supreme Court Historical Society, and I'm delighted to welcome you to our virtual platform today for the 2024 Constitution Day program. On today's date in 1787, our Constitution was signed by the members of the Constitutional Convention. It has served us ever since, with relatively few amendments. By comparison, since 1787, France has had 16 different constitutions. It's also fitting that September 17th is the birthday of the Society's founder, Chief Justice Warren E. Burger. He founded the Society 50 years ago. It's also the birthday of retired Justice David Souter, so we have a lot to celebrate today. And we're joined by two very good friends of the Society to do so, Judge John Newman and Professor Marin Levy, to discuss their new book, Written and Unwritten: The Rules, Internal Procedures, and Customs of the United States Courts of Appeals. I was just discussing with Judge Newman prior to going on air for this broadcast that the appellate courts in our country did not receive nearly as much attention as they deserve, we believe. And the vast majority of appeals from our district court decisions end there. Only 60 to 70 cases are heard from those courts by the Supreme Court each year. And the appellate courts decide over 50,000 cases a year. So we're very grateful for the work that Judge Newman and Marin Levy have done to bring more attention to these courts who deserve it and do such important work. Judge Newman is a United States Circuit Judge on the United States Court of Appeals for the Second Circuit. He assumed senior status in 1997, and at the time of his appointment in 1979, he was a United States District Court Judge for the District of Connecticut. Judge Newman was Chief Judge from 1993 to 1997. He received a BA degree from Princeton University in 1953 and his LLB degree from Yale Law School in 1956. Following graduation from law school, he was a law clerk for Judge George T. Washington of the United States Court of Appeals for the District of Columbia Circuit. And from 1957 to 1958, he was senior law clerk to Chief Justice Earl Warren of the United States Supreme Court. Judge Newman returned to Connecticut in 1958 to engage in private practice of law in Hartford. In 1960, he was appointed special counsel to Governor Abraham Ribicoff of Connecticut. The next year, he became the executive assistant to Governor Ribicoff in the latter's new position as U.S. Secretary of Health, Education, and Welfare. In 1963, after Secretary Ribicoff had been elected to the United States Senator from Connecticut, Judge Newman became his administrative assistant. And from 1964 into 69, Judge Newman was a U.S. attorney for the District of Connecticut. He returned to private law practice in Hartford in 1969, at which he remained until taking up service in 1971 as United States District Court for the District of Connecticut. And it's been my great privilege over the years to get to work with Judge Newman in various capacities with the Judicial Conference and its committees in the United States Judiciary. Marin Levy is a dear friend, is a professor at Duke School of Law. Her principal academic interests include judicial administration, civil procedure, remedies, and federal courts. Her work has been published in the Yale Law Journal, University of Chicago Law Review, University of Pennsylvania Law Review, Cornell Law Review, and California Law Review, among other scholarly journals. And she has been quoted frequently in the New York Times, the Washington Post, Atlantic, and other public outlets. Professor Levy is also a co-author of Federal Standards of Review, Appellate Court Review of District Court Decisions, and Agency Actions with Judge Harry T. Edwards and Linda Elliott. She joined the Duke Faculty of Law in 2009 and received the law school's Distinguished Teaching Award in 2017. She currently serves as the director of Duke's program in public law and is the faculty director of the Bolch Judicial Institute at Duke. She was elected a member of the American Law Institute and has testified before Congress and the Presidential Commission on the Supreme Court of the United States. She served as a law clerk to Judge Jose Cabranes of the United States Court of Appeals for the Second Circuit and received her JD from Yale Law School in 2007, where she was editor-in-chief of the Yale Law and Policy Review. She's a 2004 graduate of the University of Cambridge, where she earned an MPhil in history and philosophy. And she received a BA in ethics and politics and economics and English from Yale College in 2003. We're very qualified, obviously, our panelists today for this discussion. And we're going to begin with a discussion of the book from Judge Newman and Professor Levy, and then we'll take questions from the audience, and you can share your questions in the Q&A box on your Zoom window. Judge Newman and Professor Levy, the virtual floor is yours. We welcome you and we thank you.
Well, Jim, thank you for that lovely introduction. I have to say, at this point, I feel like we can all go home. It can't get any better than that. Well, really, it's such an honor to get to deliver this lecture today. And we thought, Judge Newman and I, that it would be fun to have a bit of a conversation going back and forth as opposed to formally delivering a lecture. So we're going to start a little bit on why we wrote the book, how we actually went about researching it, and who our intended audiences are. And then we'll get into some of the particulars of the findings. And then we're looking forward to the questions, as you said. So we were going to start off by talking about just how important the courts of appeals are. And Judge, I don't know if you want to add anything to that. Though, Jim, I think you took the words in some ways out of our mouth. Judge, is there anything you want to add just to impress upon those at home just how important these courts are?
Well, as Jim said, they are the last word on almost all of the decisions in the federal system. A lot of people don't understand that. My court, for example, produces about 4,000 merits decisions a year, of which perhaps 2 or 3 will go to the Supreme Court. So the Court of Appeals are the last word on about 99% of the decisions being made in the federal judiciary.
And so based on that, based on the significance of the courts, not only within the federal judiciary as a whole, but really within the country, one might think, well, surely we all know exactly how those courts function day to day, right? Surely we know exactly what happens from the moment you file an appeal to you get a disposition. And that, of course, the courts themselves know all these details about the sister circuits. It turns out that's actually not true. And I came to this discovery when I was a law clerk more years ago now than I would like to admit. But when I was clerking, this is the first time I learned that the Second Circuit had something called the non-argument calendar, which Judge Newman, I think, will tell us a bit more about in a minute. But I thought, what is this non-argument calendar? And one of the questions I first asked after learning about it was, well, did the other circuits have one too? And the answer that I got back from a number of judges who were nice enough to chat with me at the time was, we don't know. We don't know what the Third Circuit's doing. We don't know what the First Circuit's doing. And in fact, it was a clerk of court at the time who summed this up by saying that what we don't know about the other courts far exceeds what we do. And I think for Judge Newman and me, that really was an opportunity to try to gather as much information as possible, really about the appeals process. So again, what happens when a case comes in, thinking about motions, briefing, oral argument, dispositions, but then also stepping back and thinking about the administrative structures of these courts. So what's the role of the chief judge? What about the circuit executive? Is there an executive committee of judges who helps to oversee the court? What about various judicial circuits and conferences? So all of this is what we've tried to capture in the book, really as a way to be kind of a guide for courts and for academics. And so on that point, Judge, I think we were going to talk a little bit about the intended audience here of the book. So some might be surprised, again, as we said, the courts don't always know what other courts are doing. So it may be helpful for folks to know examples where you've learned something from another court that's changed a practice for the Second Circuit.
Yeah. Well, before I give that answer, let me just thank the Historical Society for giving us the opportunity to discuss this book with your audience. It's a real privilege for us to do so. There are, of course, many courts that do not hear argument in all their cases. There's nothing surprising about that. When Marin talks about a non-argument calendar, to us, that's a special calendar for immigration cases. And I think what's interesting is the way it came about. It sort of illustrates how ignorant we all are about what other courts do. I was in a phone conversation with a good friend on the 11th Circuit. And during the call, he said, hold on just a minute. I have to cast a sequential vote. And I said, what the heck is a sequential vote? I've been here a long time, but I've never heard of such a thing. Oh, he says, we use that for certain motions. We don't meet, the papers go to the first judge. The judge sends it to the second judge a few days later and sent on to the third judge. And they vote in sequence, and then the matter is disposed of. And since I was concerned with the huge backlog of immigration cases in our court, I said, well, that's brilliant. I've never heard of it, but it sounds great. And so I brought it to our court and we agreed to do it. But it's simply an example that things are going on in the circuits and the other circuits don't know anything about it. We meet at committee meetings or conferences, and occasionally we gossip about some practice. But there's no formal way, there's no collection of all the different ways we do everything. And that's really the idea of this book. But I want to emphasize, it is not a book that urges any court to do anything in particular. We simply think they ought to know about what every other court does on the myriad practices that are pursued in each of our courts. And that's the purpose of it. Many of these things are written. There are local rules, as many of you, as you know. There are internal operating procedures. There are things called general orders, which some of you may not know about. And then, as the title of the book, Written and Unwritten, suggests, there are just customs that have grown up through the years in some courts, and nobody writes them down. They're not. It's not that they're great secrets. It's just that nobody has bothered to write them down. There are even some practices within a court that nobody knows about. One clerk said to us, I've been on this court for 38 years and I'm still learning how we do certain things. So that's just an illustration of the fact that there, I think, is a need for this collection. It amazes me that the book wasn't written 20 years ago, but in any event, it now collects them all. So I'll let Marin talk about some of the things that she wants to highlight.
Sure. And so just as Judge Newman said, I think a clear audience in mind here really is for the courts itself, for judges, clerks of court, circuit executives, just to know what the practices are in other courts, but also for practitioners and for academics. The fact that we find so much variation across court practice, I think, is a real opportunity then for academics to come in and try to study, what do we make of these differences? Kind of what effects might these have? So I think of this also as a kind of collective research agenda going forward. So one question then is, how do we actually collect all the data that goes into the book? And as Judge Newman said, part of that answer is we went through the local rules, the IOPs, the general orders, the various handbooks, guidebooks that exist across all the courts. I think every time we did that, it was like going into a new country, right, where you're trying to learn the language and see exactly where this information lies. But anytime you're trying to learn about customs, things that aren't written down, almost always you're going to need to use some sort of qualitative method. So for that, we actually used interviews and surveys. So I think something that was particularly fun for both of us at the beginning of the project, we conducted what we call semi-structured interviews of all of the chief judges of all 13 courts of appeals at that time, and then a number of past chiefs as well, just to try to get a lay of the land for how court administration really occurs in their circuit. And then in addition to that, we were very grateful to the clerks of court of all the 13 courts of appeals. We sent them detailed surveys asking them about their particular practices. Of course, invariably what happens when you do that is you'll ask someone, so in your circuit, do you do X or do you do Y? And somebody will come back a little bit later and say, actually, we do Z. And you realize you have to go back to everybody and say, wait a minute, we need to actually ask you a follow-up to that question. So we had much back and forth with the wonderful clerks of court. And they were also gracious enough to review the manuscript from front to back, just to make sure that we weren't missing anything. So that's how we went about actually researching the book. And then from that, as we said, we found a number of really interesting points of variation across the courts from every single aspect, whether we're talking about briefing, argument in banc, and so on. And so we thought we would touch on just a few of those that are particularly interesting to us, and then talk about some of the unique provisions, some practices that only one circuit actually engages with. So on the briefing front, to everyone in this room, I'm sure will know how important briefing is. And you might think, well, surely across the courts of appeals, we're consistent when it comes to briefing, right? We're talking about how many words you're allotted in an opening brief. Surely that would be consistent. You might think the timing, when a brief is due, surely all the courts have a uniform approach. So as it turns out, that's actually just not true, which we learned about when we were going through these practices. And so, Judge, I think you're going to talk about the Second Circuit's approach to briefing deadlines, because it's quite different from what so many of the other courts do.
It is. There, of course, is a national appellate rule on time limits, but it has a loophole, and it says the time for the brief is X, but it can be extended. The Second Circuit has taken advantage of that, because what we found is if we follow the 40 and 30-day limits of the national rule, we were besieged with motions to extend the deadline, and these were regularly granted. And all that was happening is judges were being bothered with motions for extension, which were generally quite legitimate and being granted. So we said, well, that's kind of ridiculous. Why don't we have a large extension to begin with? So we set the timing for briefs not at 40 days, but at 90 days. And we also said the parties can set their own preferred briefing deadline at any point within the 90 days. I don't think any other court does that. And that has worked very well in the sense that we no longer, well, hardly ever get motions for extension. And if we do, we're pretty tough on them because we've given you up to 90 days and we think that's enough. That has a price. It sort of slows our process a little. But and many parties don't demand the whole 90 days. They set a date at 50, 60, somewhere in there. And we're at least relieved, our judges are relieved of this flow of motions for extension. And that works very well, at least for us.
So you see something similar unfold when it comes to the word limit. So of course we have a federal rule, again, I think of as a national rule on this point, right? So what FRAP tells us is that you're not supposed to go over 13,000 words in your opening brief. Makes sense. But of course, there's variation on this. So it turns out there are quite a few circuits that actually say you can have upwards of 14,000 words. So I was quite surprised when we came across this, because I thought, why on earth would a court ever be inviting even more words? I would think that they would be interested in keeping that down. But the story that we heard is just as Judge Newman was describing in the context of the deadlines, right? That the circuits that decided to increase the word limits had found if they didn't, they were getting all sorts of requests to go over the word limits. And so they thought it would be easier as a matter of course and just more efficient for the clerk's office to just start with a higher number, right? And I think it just highlights here these really interesting policy choices that the courts are making, right? You know, do you go shorter and allow for lots of extensions? Do you go longer or not, right? Again, some of this having to do with resources in the clerk's office. Another point of variation that we found when it came to briefs was actually what should be contained in the briefs. So this is another point where we have FRAP giving us some information. So in this case, it's Federal Rule of Appellate Procedure 28, tells us that an opening brief should include a statement of the issues presented for review, concise statement of the case setting out the relevant facts, and the argument itself. Makes all kinds of sense.
Well, in that vein, there's another curious one that's a conflict. As you all know who have argued appellate cases, it's customary after an adverse decision to file a petition for rehearing to the panel and a petition for rehearing in banc. Well, two courts say, and most people file both. So one court says, if you're going to file both petitions, they must be in the same document. And that makes sense. But another court says they may not be in the same document. So a lawyer better check his or her circuit and find out either there's no rule on it, which is true in many circuits, or there is a rule, but the rules conflict. It's just a curious example of circuits doing it differently for no apparent reason, if I may say so.
if you may say so. I think you have the Article 3 privilege here. You may say so. But just finishing us up on briefs for a moment, right? So you have a federal rule that says generally this is what a brief should look like. Makes all kinds of sense. But then what's interesting is you have each of the courts weighing in and saying, here are additional criteria that we want you to include in your brief. And it's really fascinating. So for the First Circuit, we say that an appellant's brief must also include the text of the decision appealed from. Right? Clearly, along the way, someone thought that that was very useful. And so that's now become a local rule. The Second Circuit, Judge, I have to give a shout out to the Second Circuit here, says that a brief must be concise, logically arranged with proper headings, and free of irrelevant matter. I love that language. I think that maybe law professors should start using that for our law review articles every now and then, right? But you think sort of, at what point someone decided to insert this, but adding it on top of what FRAP has already told us, right? Just interesting to see this kind of variation. So another place where we saw significant variation has to do with oral arguments, right? So at the outset, I think anyone who argues before the courts knows there's significant variation when it comes to how often appeals are actually getting argued at the different courts. So this is data that we present in the book that we get from the wonderful AO, right, that keeps track of this. So if we were looking to see the percentage of cases that are decided on the merits, so how often that's happening after argument, there is a huge range, right? So the Fourth Circuit, the circuit where I live, right, that figure is at 11% right now, right? So that means almost 90% of the cases are being decided based on the briefs and not after argument. If we go all the way in the other direction, what you find is that actually we have the Second Circuit with 30% of cases being decided after argument when they're decided on the merits. The DC Circuit's even higher, that's up to 35%, right? So that's a point you see significant variation.
Yeah, our percentage is in practice a little higher because we put a lot of the immigration cases for non-argument. But if you cut out the immigration and just talk about everything else, we argue a fairly high percentage of cases. The one interesting thing about that huge difference, one is that it's rarely reported, but the second one is that those courts that have a fairly low percentage of oral arguments of their whole caseload have a separate track for determining whether to have oral argument. They vary on who does that. Sometimes it's a motions panel, sometimes it's a screening panel. In one circuit, it's the circuit executive. But the point, where it's a panel, it means 3 judges have to look through all the papers to decide whether to have oral argument. And then weeks or months later, another panel has to look through the papers to decide the merits. So 6 judges are involved in most appeals. Our circuit, the Second, thinks that's not a good idea. So we would rather let the parties ask us, do they want oral argument or not? And if they want it, we grant it. There are a couple of exceptions. We don't bring a confined prisoner in for oral argument. But for the most part, the caseload of our court, the people who want oral argument get it. And that means that only 3 judges are devoted to each case instead of 6. We think that's an important difference and a great benefit to the flow of cases in our court.
And just on this point, you can see, though, why different circuits end up with different approaches here. Having spoken to judges in these various courts, but I think for some, there's a concern about requiring oral argument. And then, the litigants will have to travel, say, to one place that may be several states away, and the kind of costs that they incur, right? That kind of trade-off might feel different in different circuits. And so you can see, again, why these are ultimately policy choices that are being made with a real weighing of the costs and the benefits, and those might just come out differently across different courts.
Sure.
One of our other favorite points of variation, this might seem almost trivial, but ends up having, we think, an interesting impact. So of course, when you're arguing before a panel of 3 judges, there's a question of when you will find out the identity of the panel members. And again, one might not expect there to be any variation on this score, but it turns out that there is. So on one extreme, you have the DC Circuit, which lets the parties know 30 days before argument who exactly will be hearing the appeal. And then you actually have several circuits that say, we won't let you know until the day of argument. So the Fourth, the Seventh, and the Federal Circuit, you are finding out the day of who will actually be deciding your case, right? Again, you can see what the different kind of considerations are there. I think for some courts, the thought is we'll be transparent kind of as early in the process as possible. Other courts might worry about the effects of revealing this kind of information, right? Maybe litigants will start pitching their arguments to particular judges if they know who will be on the panel. But as a result, then we get all of this variation across the courts, which we thought was particularly fascinating.
Well, it's a big difference. I was of all the, and there are many differences we've noted, but that one surprised me a great deal, that there isn't either a national rule or an informal national policy among the courts as to when lawyers find out who the panel is. And it has consequences. When there's a long time between when you find out and the argument, some lawyers, let's say the mischievous ones, who look at the panel and say, we're not too thrilled with that panel, will find a motion for a continuance and get it bumped to another panel. If the court gives you the argument, the panel composition the day of or the day before the argument, that practice is impossible. So it's not only a variation, but it's a variation that has consequences.
So thinking about argument, of course, one very interesting time when we see argument under the courts of appeals, of course, is in the form of in banc, right? So this is a topic where there's variation.
Yeah.
And
well, but before you get to in banc, can I just say, put in, even in panel arguments, one of the big differences is how much time the courts allow for oral argument. And it works this way. The courts that hear very few cases give a fairly long time, perhaps a half hour aside. The courts that hear a lot of cases like ours start out at least with very limited time, about 10 minutes or 15. If the argument is fascinating, of course, we let it go. But we start out with limited time, and other courts that don't hear many cases start out with a lot. I have said at Bar Association, which would you rather have? A lot of cases argued for a short time, or a few cases for a long time, or all cases for a short time. And invariably, the lawyers say, please give us argument in almost every case if we want it. We want to have the opportunity to be in court, look you in the eye, and be sure that you know about our case. If there's no argument, the lawyer just doesn't even know who looked at the papers. They hand them in, they get a decision 3 or 6 months later. They have no way of knowing, did the panel really understand the issue? Whereas with oral argument, they're there before us, they get to tell us exactly what their point is, and they get our reaction. I'm not suggesting that oral argument determines the outcome in a vast number of cases. I don't think it does. Once a district judge has written a long opinion and the loser has written a 50-page brief saying it's wrong, we have a pretty good idea how that case is going to come out. But oral argument is there so that there's legitimacy. They have the chance to look us in the eye and be sure we understand their point. And I think it's right that ours is one of the courts that grants oral argument in a large number of cases.
So I'm just going to say a word about in bancs, because I think not only is this such an interesting practice of the court where we see variation, but we see variations that we might not expect. So taking a step back, I think anyone in the room will say, surely there's going to be some variation across the circuits with practices that affect things like, the size of the courts, the geography of the courts, right? Like there are significant kind of considerations there. And we see that, of course, within bancs and in a very clear way. So by statute, Congress has said, if you have more than 15 active judges on your court, you can exercise a power to have a limited in banc. Right? So you don't have to have all of the active judges meeting to decide the case. So currently there are 3 separate courts of appeals that are eligible, right, to exercise that power. Only the Ninth Circuit has. And so the Ninth Circuit has a local rule that speaks to exactly how they create their limited in banc. So that's for them, a court that's made up of 10 active judges and then the chief judge. So fine, one might expect variation on that front. A smaller court like the First Circuit doesn't need to have a limited in banc, couldn't even have one. So we're not going to see provisions on that. But what's really interesting, again, when we're thinking about the differences across the circuits is just how frequently or not the courts are actually holding in bancs. So there are some courts that I think quite famously have held out. They try to avoid having in banc arguments whenever they can. this is a number that they feel like they should keep low. Other courts haven't expressed that same kind of interest. So again, we have a table where we have 10 years worth of data on the score, and we see a significant range. So in the First and the Second Circuit over this 10-year period, we actually only have 7 in-bank arguments, right? So fewer than 1 per year. You look at the Fifth Circuit, there are actually 58 in-bank arguments at the same time period. So again, it's not the kind of thing that you would think you could explain by geography or the size of the court. That really, again, is about, you know, the kind of different norms operating in the background, and something that, you know, we think is worth people knowing about. The final set of variations that we wanted just to talk about briefly has to do with moving the business of the court, as one might say. And Judge, as a former chief judge, you may want to explain what that exactly entails, and what the problem is that one maybe is trying to solve with moving the business.
Well, it's a great problem for every court, particularly a group court. There are always going to be some judges who are do their work rather expeditiously, and some who don't. And the problem all chief judges encounter is, what do you do if a particular judge or two is way behind in his or her work? And the practices vary considerably. At the bottom end, they do virtually nothing. Some feel an obligation to call a judge who is delinquent and just have a friendly chat. Most courts have a reporting mechanism of some sort, although the nature of the reports varies tremendously. But in essence, they are a way of bringing to the attention of the court, perhaps quarterly, which judge which cases are behind, let's say, not filed within 90 days of the argument. The time limits vary. What they do with those reports varies tremendously. Some just circulate them to the court, to each judge individually, and that's the end of it. Our court, at our quarterly meetings, reads the list. And it's frankly a sort of shaming exercise, so that everybody knows that judge is behind. And hopefully the fact that it is read at the court meeting exerts a little pressure. Sometimes it works, sometimes it doesn't. Sometimes courts are inventive in what to do. I can tell you one example I had. When I was chief judge, I had a judge very far behind in cases. And so I called him up and first urged him, and that didn't do much good. I called him later and said, look, it's now really out of hand. What I'm going to do is take away some of your sitting days down the road until you get caught up. He was understandably distressed, but he said, well, that'll look terrible. I said, no one will know except you and me. We have a calendar with blank visitor days on them. And I will just, in fact, nobody looks at the calendar for the year except to see their own sittings. They don't look where everybody else is sitting. So they won't even notice that you're deprived of 2 days. And I'll fill those in. And when you're caught up, I'll put them back, which I did. He caught up. Nobody on the court knew about it. So you can take steps like that. There's one court that says in their local practices, the chief judge can designate a panel of judges to examine the delinquencies. It's not clear what they do after they examine the delinquencies, but presumably they do something to try to get the caseload moving. It's a difficult problem in every court of appeals, and their responses vary considerably.
Yes, and I think just one point to add to that, I mean, this is a real place, again, where we're thinking about customs, norms. For the most part, this isn't written down. This really is just what are the individual practices of the chief judges and their courts. And we were given other examples from chief judges. In the Third Circuit, there was an instance in which a staff attorney had been assigned to chambers to help with a backlog. We heard other examples of calendar relief. This was true in the Fourth Circuit in a particular case. So this was a really interesting, from thinking about just from a research perspective, getting to learn about what different courts had, what kind of tools they had reached to when trying to face this problem. And then there's just one more point I'll make on this, which is in the DC Circuit, we see a very special rule. So it's the DC Circuit that says, if we have a judge who has more than 2 opinions outstanding come August, that judge is not going to be put on the calendar come September. So this is the same sort of thing that we've been talking about with calendar relief, except that it's done by rule as opposed to, say, an intervention on the part of an individual chief judge. And one thing that we found that was really, I think, fascinating was other judges then learned of this. And we had an example with one chief judge who we were in conversation with who said, I didn't know about this. This seems like a great idea because it's a court rule as opposed to me, the chief, having to come up with it. I'm going to try this in my own court. We'll see if, we can get some takers. So that's the kind of uptake that we are interested in hoping for with the book, that as people learn about these practices, they might think perhaps that's something for our own court to adopt.
Of course, lawyers have the opportunity to write a letter to the clerk and simply point out their motion or appeal has been pending a considerable amount of time and expect that letter to be circulated to the panel, which it is. But some lawyers are reluctant to do that, figuring that's not going to enhance their position with the court if they're always complaining. So in this connection, I was very interested to see a Ninth Circuit rule. They're the only one that has a rule like this. It says, parties are encouraged, this is the local rule, parties are encouraged to contact the clerk if a motion has been pending for more than 4 months. They're the only court that has a rule that actually encourages the lawyers to come in and complain about a delay. I think that's a very good practice. I think I'm going to recommend it to our court. But the important point, like so much in our book, is they're the only circuit that has it and nobody else knows about it.
So Jim, we could go on about some of the unique provisions, but if there are questions that you want to get into, we can do that. And then
can I mention one little one?
Sure.
There's one little practice, but sometimes the little ones are the interesting ones. And this one fascinates me. In the federal circuit, and this is the only circuit that has it, it says their policy is, in order to show respect for the judgments being reviewed, references should not be made to, quote, the court below, the lower court, the judge below, but should always say the district court, the trial court, or the district judge. Now that's a pretty small variation, but it fascinates me that one court takes the trouble to say, we are not going to refer to the courts as the lower court or the lower judge. We're going to call them the district judge. No other court has that. I think other courts will be interested. Whether they adopt it or not is up to them. I think they'll just be interested to see that one court has put that into their local rules. Go ahead.
I thank you both so very much. And we do have some questions from the audience. The first of which you'll be delighted to hear. How do we buy this book? And I am delighted to say that we are going to be carrying it in our gift shop at the Supreme Court. And you can get it on www.supremecourtgifts.org. And you all may have other suggestions as to how it can be purchased. But that's a good sign. That was the first question out of the block.
It is. I love the question, of course. But we have to make full confession. Our publisher, Cambridge University Press, which we're delighted to have as a publisher, ran into a problem. They were hacked. Their computer system was hacked. And that has caused a delay in publication. So that while I guess it can be ordered, but delivery probably won't happen until either the end of the year or possibly into early next year.
Yes, we just got good news this morning. They're thinking end of November, early December.
Oh, good.
Yeah.
That is good news, and we will do our best to keep it on everyone's radar. I will especially. I can't tell you how thrilled I am about it. I don't know how many of their people like me out there on this, but I'm thrilled about this book. Having served as the secretary of the Judicial Conference and director of the administrative office for a number of years, you were hitting on, in just even this discussion today, and I'm sure in more detail in your book, notions of federalism within the judicial branch itself.
Yes.
And it is such a little known fact about the judiciary, and I think you're highlighting some facts that really come into play when when there comes criticisms of the court system, that we really have these elements of federalism where the circuits do differ.
Yes.
Circuit to circuit. Now, it's the job of this is a long question. It's a long wind up for the pitch here, but there's some effort made within the judiciary and its structure to have a strong central government, if you will, for rules. But as you've pointed out, there are many differences among the circuits, even in their rules. The question I have is and why I'm so happy about the publication of your book is the notion of best practices. What you are doing with the publication of this book is also a function that we tried to do while I was at the Administrative Office of the Courts, and I know they continue to do so. And that is to highlight for all the circuits what other circuits are doing for purposes of each circuit determining what might be the best practice. It's also helpful in rulemaking that does apply to all the federal courts. We had particular challenges during COVID. How were the circuits reacting during COVID to their workload? How were they moving criminal cases along? That was a long wind up, but here's the question. Did you look into those differences among circuits? Was it a little too fresh to make observations about that? And that is,
I think it's fair to say our general approach, I would say really our universal approach, was simply to report.
Yeah.
We're as I said at the outset, but it's worth saying again, nowhere in the book do we tell or even recommend to a court, well, you ought to adopt this practice of the other circuits.
Mm-hmm.
And another point on that is this. There's always a little tension between uniformity and particularity among the circuits. And that's understandable. The circuits are different.
Mm-hmm.
Our court has 3 states. Some circuits have 8 or 10. And the size influences what they do about certain things. I don't think a uniform rule should ever be imposed unless there's a good case for it being uniform.
Mm-hmm.
And that the proponents of it have recognized the geographic and perhaps structural differences among circuits. So, the virtue of the country is it's got 50 states. Well, the virtue of the federal appellate system is it's got 13 circuits. But I think as the circuits look at this book, which I hope they will now that they know they can get it from the Historical Society, is that they will see things that they might like to consider and
Mm-hmm.
bring to their courts, either exactly what another circuit does, or perhaps a useful refinement on what another circuit does. For example, every circuit has a website. And the websites are loaded with headings and links that lead to a fund of information, but they are astonishingly different. They're even different in how you locate a similar topic. If a disabled person wants to know what's the system in your court for getting access to a court, one website has a link called disability access. Well, that's pretty clear. Another has a 5-step progression of links before you get to disability access. Well, I don't think many people are going to find that. So that's the kind of thing that we do recommend they look at that.
Yeah.
And some have website links to topics that other websites don't have at all.
Mm-hmm.
And those are not due to the size of the circuit or any structural difference. It's just the preference of the webmaster, I guess they're called, who design a website. That's all way above my pay and grade. But there are these differences, and it's one example of something that can be looked at to see if there's some things they'd like to adopt from other circuits.
It's enormous service you're providing to the federal courts to publish this. I can't say that strongly enough, and I'm very grateful. We have a number of other questions, and one of which you mentioned the fact about oral arguments, and a question, how important do you view oral argument? You sort of touched on that after the question came in, but I would just, maybe I'll refine it a little bit. Has oral argument ever changed your viewpoint? You had mentioned, Judge Newman, that by the time you get to oral argument, the briefings have all been done and studied. Pretty much, you kind of know which way the decision may be headed. But in your experience, also, has oral argument changed your viewpoint in experience?
Well, the honest answer is hardly ever, but it has happened.
Yeah.
It has happened. More like when there's a change, it's not necessarily in the outcome, but it may affect the ground. It may enlighten us a little more about what happened in the trial, that we asked the lawyer, did you, for a simple question, did you object to this? I've had the wonderful experience of asking a lawyer, did you object at that point? And his reply is, well, there's a Fifth Circuit court case that says such and such. And I say, that's not what I'm asking you. Did you object? And he'll tell me. Or they may not have realized that there is a point worth developing. And we, for example, jurisdiction is a common one.
Mm-hmm.
Have you focused on whether we have appellate jurisdiction? And because I know the answer, because his brief doesn't do it, but I still want to confront him with it. And he said, no, Your Honor. And my usual response to that is, would you like a few days to send in a supplemental letter giving your views on appellate jurisdiction? Well, I think that's a useful exchange, and it wouldn't have happened unless I had the lawyer in front of me.
Right, right. Another question, why are so few immigration appeals granted? If that's true.
Oh, I think I can take that.
Yep.
First of all, there's been a change. When the flood of immigration cases hit our court in about 2004, when the Board of Immigration Appeals, responding to pressure from Congress, literally dumped 35,000 cases on the Court of Appeals. One judge, one member of the BIA, and one word, denied. Those cases in the early days sometimes involved nice statutory questions. And we wrote opinions and resolved those, as other courts did around the country, the Ninth particularly. The Second and the Ninth get about 70% of all immigration cases. As the statutory questions got resolved, really the only question, well, only is too strong. I would say 98% of the immigration cases we now get, the sole question is whether the credibility finding, usually the adverse credibility finding by the immigration judge, is supported by evidence. And the review statute that Congress has passed limits our review astonishingly. It's one of the strictest review things. It says you can't, when the district judge makes a finding of fact, we can reverse, says the Supreme Court, if we are clearly convinced that the finding is wrong. We can't do that with an immigration finding. It has to be, would a reasonable person be compelled to find the opposite of what the district judge found? That standard is unknown to the law except in immigration. And it's supplemented by a rule that Congress has passed. We used to say, the immigration judge used to say, excuse me, well, there's some inconsistencies in the plaintiff's petitioner's statement. Well, of course there are. They gave a written statement 3 years before at the border, and then they testify at a hearing 3 years later. Bound to be inconsistencies. And we used to say, and the statute said, well, if the inconsistency was significant, maybe that's a reason, but you can't just take any trivial inconsistency the way they sometimes do. He says, well, at the border, I was beaten in April 3 years ago. And then at the hearing, he says, I was beaten in March. How many people remember exactly 3 years ago which event it happened? Congress said, now any inconsistency counts, no matter how trivial. Again, an astonishing restriction. So because of those restrictions, it is a rare day when we can say an adverse credibility finding it can be upset by us. Very rare.
No. Thank you.
Jim, I don't mean to take us backwards, but
sure.
I was just hoping to say a word because you were talking about the COVID procedures, and
yeah.
just want to say a word about that and about federalism, if I could. So we had the really interesting experience of beginning our interviews actually as the pandemic hit. And so we began conducting our interviews over Zoom, something I'm not sure we would have done prior to the pandemic. And something I think that was really interesting about watching that all unfold was, as you know better than anyone, the courts tend to be kind of small c conservative institutions. We don't see significant changes in practices generally overnight. And that really was a time when, as you know, again, the courts rapidly shifted how they were hearing cases. And so we did, in fact, update that in the book. So we had initially had some discussion of remote argument. And in the book now, we actually talk about the way that was conducted during the pandemic and then what remains of those practices. And that's another point of variation. There's some courts that actually have now like a fair amount of, or I would say compared to where they used to be, remote argument. And there are others that really strongly discourage it. But that's something that we cover. And then just on the federalism point, I did want to add, I mean, part of what's so fun about this area of study is we see, of course, the variation, as we've been talking about, across the different courts, the kind of lack of uniformity in some ways. But I think one other part of the federalism story that is so rich is the relationship between, as again, you know better than anyone, what's happening with the courts and what's happening at the national level. So one of the examples I love that we touched on already has to do with the in-bank practices.
Mm-hmm.
So it's Congress that comes out, and Congress says to the courts, if you have more than 15 active judges, you can, if you want to, have a limited in-bank. And you can decide how you're going to do that through your own local rules. And that's just a fascinating way of sharing that power, right? It's Congress, of course, coming out and saying this is the way it should be, but then giving a huge amount of discretion to the courts themselves to decide if they're going to exercise that power, and if so, how, basically inviting the variation that we see.
Yeah, comity, not comedy, comity
Yes.
is much appreciated there.
Yes.
Yes.
It is interesting, but it also illustrates another point. It's the rare case where Congress has bothered to turn its attention to procedures within the Court of Appeals. Right. It's just not an exciting topic.
Right.
Quite understandable.
To them, not to us.
So pretty much they leave it up to the different committees of the conference, right, and their reporters to come up with something that they think needs a change. And I want to be clear on one thing that I guess is obvious, but we didn't say it. Nothing in this book discusses the substantive decisions that the courts of appeals are making. There are thousands of books on how courts interpret the First Amendment and every other amendment. We're not in that business. So this is not a textbook on substantive differences. It is solely concerned with internal procedural differences.
And a very important topic, and as we discussed before the program, hard to believe it's never been written about before. During COVID, I'll just add to what you were saying, Marin, that we were coming out almost weekly. We were at the administrative office of the courts. We were compiling what courts were doing and different circuits were doing around the country and dealing with the cases, and putting out a compilation of practices. And much like you're suggesting in your book, Judge Newman, where you're not telling anyone what to do, if you lay it all out, and the courts will come to their own conclusions as to what best practices might be. Yeah. I think the light kind of goes. It's very helpful to share this kind of information across the circuits, so they can change their practices.
Well, here's one, if I can mention it briefly. When the Supreme Court tightened up the rules on pleading, as your audience I'm sure knows, there were some district judges who were dismissing complaints perhaps a little more frequently than they would have done under the old Conley and Gibson rule. And I got concerned that maybe too many were being dismissed at the outset that perhaps shouldn't have been. In any event, I went to the court and I said, look, if we reverse at the end of a trial, they can wait a bit. The trial's happened and they can wait a bit. But if a complaint is dismissed at the outset, it really ought to get, and we think it should be reversed, it ought to get back to the district court ahead of the other cases.
Mm-hmm.
And they said, okay, what do you got in mind? I said, I think we should have an expedited appeal calendar on which we will place every case that was dismissed at the outset, either for lack of jurisdiction or failure to state a claim. So we instituted that. We're the only court that does it. And it means that in those, there are not too many cases, but sometimes we reverse. And it gets back to the district court while the witnesses are still alive, their memories are still somewhat fresh, instead of waiting, taking its place at the end of the entire queue of all appeal cases. I thought and still think that was a very important innovation our court did, and I hope other courts will be interested in knowing about it.
That feeds into another question. We have a lot of questions, and I'm not sure we're going to have time to get to all of them. It's very good. It's been very engaging. The question is, deliberate speed is the law of the land. What did you see about too expeditious a response, leading to perhaps sloppy decision making, if anything?
You mean in the expedited appeals that we did?
Yes.
No, well, I guess this is a self-serving answer, but no, I don't think we're being sloppy.
Okay.
Sometimes the lawyers ask for expedition, and we typically grant that. A prisoner may be on a short sentence, and if we don't decide the appeals quickly, the sentence will be expired by the time we get around to it. So we get expedition motions. I think we generally grant them.
Mm-hmm.
I have had cases where the defense lawyer is there arguing a point, but his client is in jail, and I say, "Have you asked for expedition?" And he says, "No." I said, "Would you like to?" He says, "Oh yes, I really would like to." I said, "Granted."
Well, that's not sloppy. That's good. That's all deliberate speed.
Sure.
That's great. Would you discuss the differences among the circuits as to how they invite district judges to sit with them?
Oh, well, Marin's the expert on that.
The judge is being too kind. He's saying that because I wrote a law review article on the practice of sitting by designation, the use of visiting judges across the courts. There is significant variation on that as well. Of course, they're only, when it comes to borrowing other circuit judges, only some of the courts can do that. When it comes to actually having district judges.
Are you frozen?
Oh.
Yep.
When it comes to.
We seem to have a glitch here. Are you here, Jim?
Yeah, we're okay.
Yeah.
On our end.
When it comes to inviting district judges, there's some circuits.
I think her picture is frozen.
Oh dear. I think that may be on the judge's end. Well,
there you go. Go ahead.
I'll just say, so right, there is variation on this score. So there are some circuits that routinely bring up district judges in part so that they can learn about the practices of the courts of appeals. That's not something that is done ubiquitously, but I'm happy to talk more about that offline for anyone who's interested.
Right.
There's a very lengthy law review article.
An example of how it's done. Years ago, the seventh, most circuits stopped having.
Oh dear.
I think we
visitors, and I said, "Oh, it wasn't contentious at all." Judge Posner, as chief judge, just said, "We're not going to have visitors." So not only do they vary in their practice, they vary in who decides.
Interesting. Last very quick question: do any of the circuits borrow ideas or procedures from state appellate courts?
So that's something I can answer, and the short answer is very little, at least not that we came across. And in fact,
you froze just at the answer.
So Zach Clopton and I at Northwestern, we've been doing also a separate project on local rules, and it's the same thing. We're finding there can be borrowing from other federal courts, but almost never from state courts.
Thank you. Well, I think there's a connection.
Almost never. Yes. Go ahead.
Yeah. Yeah, I think we're there. We have a number of other questions. Unfortunately, we're not going to have time to get to.
No, she's frozen. Jim, do you hear her?
Yes, we can hear you, Judge Newman. But we're about to conclude, and thank you so much for this wonderful presentation and your great work, which I think is so important for the country and for our court system, that people understand the value and importance of our courts of appeals. Again, copies of Written and Unwritten, the Rules, Internal Procedures, and Customs of the United States Courts of Appeals will be available at our gift shop at the Supreme Court. It's www.supremecourtgifts.org. I encourage you to add it to your collection. And I would invite you all to join our next virtual program, which will be at noon on October 9th. We're going to be in discussion with the Curator's Office of the Supreme Court to discuss their good works. And then on October 30th, when I'll be joined by Douglas Rooks to discuss his new book on Chief Justice Melville Fuller. We are also jointly hosting an in-person lecture at Mount Vernon with George Washington's Library, that organization, on October 8th. Information and registration for these events will be on the Society's website at www.supremecourthistory.org. And finally, a survey link is in the chat. Please do respond to it. We added these virtual programs during the COVID pandemic, and we plan to continue to utilize them. Your feedback is very important to us in making these as informative and engaging as possible. I want to thank again today Judge Newman and Professor Levy. This was a great presentation, and you've done a great service to the country and the judiciary in particular with your good new book. And thank you very much. Thank you for joining us.
Thank you.
And we are adjourned.